Does every estate in Minnesota have to go through probate? Absolutely not. And that surprises many families. There is a common assumption. Someone passes away. The family says, we need to start probate. But probate is not triggered by death alone. It is triggered by how assets are owned at the time of death. The distinction is critical. It's not about the value of the estate. It's not about whether there's a will. It's about title. And misunderstanding can cause unnecessary stress. One of the first steps we take with Minnesota families is evaluating asset structure. Before filing anything, we determine whether probate is legally required, because sometimes it simply isn't. Let's break this down clearly. Probate is generally required when an individual owns real estate solely in their name. There are financial accounts with no beneficiary designation, and there are assets titled individually without joint ownership. In these cases, probate court provides the legal authority to transfer title properly. Now, here's when probate is often avoided. When there's beneficiary designations with life insurance policies, retirement accounts, or there is brokerage accounts that have transfer on death designations, these assets pass directly to the named beneficiary at death. If a couple owns a home jointly with right of survivorship, the surviving spouse automatically becomes the full owner at death. That transfer happens by operation of law. No probate required for that asset. If you have a revocable living trust and your assets are properly titled in the name of that trust during your lifetime, then those assets can avoid probate at death. Again, no probate. But this is important. A trust only avoids probate if it is properly funded. Creating a trust document alone does not prevent probate. Assets must actually be transferred to the trust. Imagine two Minnesota residents. Both have similar net worth. The first owns a home solely in his name and has an individual bank account without beneficiary designations. Probate will likely be required. The second owns property jointly and has beneficiary designations in place, or has a funded revocable trust. Probate may not be necessary at all. Same state, same assets. Completely different outcomes. The difference is the structure. The real question is not, will my family go through probate? The real question is, how are my assets titled right now? Probate is not a reflection on wealth or complexity. It's a reflection of planning. And thoughtful planning creates options. Without it, probate becomes the default. If you're unsure whether probate is required in your situation, or you want to structure your estate to minimize court involvement, schedule a consultation with our firm. Clarity around ownership today prevents confusion tomorrow. And in estate planning, structure determines outcome.